Hi folks, and welcome back to Contract Law. This is the video series on consideration, and this is a final postscript to the video series on consideration. Small postscript, I promise, given the fact that we have had an epic journey in exploring the principles around consideration for this week. What I need to actually discuss with you in this particular sub-series, short, as I said, I promise, is the doctrine of Estoppel, because we've just finished saying that there are a couple of exceptions to the fact that consideration must be present in order to have a legally binding agreement. We had a brief look at third parties paying the debt for the original contracting party. We also had a look at personal insolvency agreements. And Estoppel is the other big exception where you might be able to enforce a promise without having paid consideration. So jumping into our present now, the first thing to note is that there are two types of Estoppel: Estoppel at common law and Estoppel in equity. And we'll be talking about the differences between common law and equity much more in a later video series. But for now, it's just, I guess, a side note that there are two different streams of case law dealing with Estoppel. As I said, the first one is Estoppel at common law, which we call Estoppel in pays. Essentially, there are three things to note about an argument of Estoppel in pays. It's designed to prevent a person unjustly departing or resiling from an assumption of past or existing fact on which the other party has relied, and which will cause detriment if the first party does actually resile from that situation that has been assumed by the other party. Now, Estoppel in pays is only really a rule of evidence, okay? So all it does, it helps the court work out the factual basis for a particular cause of action, okay? So Estoppel in pays is certainly not a cause of action of itself. It's not a source of rights that can be enforced. It's simply a means of stopping the other party from arguing that a particular fact that has been assumed is not the case, okay? So that's Estoppel in pays. Like I said, really just a side note. Equitable Estoppel grew out of a couple of 19th century railway cases, the Hughes case and the Birmingham case. And the upshot of those cases was that if parties are already in a contractual relationship, so they have a pre-existing contract, very important point to note there, as you'll see later, and then they negotiate about something, and those negotiations suggest to one of the parties that the first party won't really worry about enforcing their strict legal rights against them, then where that party has allowed that mistaken assumption to go ahead and the other parties relied on that, then equity would prevent the other party from going ahead and reneging on what they've suggested and actually trying to enforce their strict legal rights. That, in the eyes of equity, would be a problem. You know, it's kind of like going back on your word, if you will. So those two cases were quite a watershed in recognising in equity that a party would have recourse to prevent somebody else from going back on their word. Then we had the landmark decision, Lord Denning decision, yet again, of High Trees, decided just after the Second World War. And in that case, we had a block of flats that was leased to a tenant. So they were the main head tenant, if you will, of this whole building that included a number of different flats. That head tenant paid what we call a ground rent for the building of flats. And during the Second World War, times being tight, not all of the flats were actually let out to subtenants. So the head tenant was having trouble paying the ground rent for the entire building, as you can imagine. So the landlord and the tenant got together and they worked it out. They came to an agreement whereby the rent for the ground rent for the whole building would be reduced by half. Now, the agreement was kind of indefinite as to when it would finish. After World War II, things improved for the tenant because the number of tenancies in that building increased and they were more able to pay the rent. However, for the landlord, things weren't so rosy, and the landlord actually went into receivership. And what happened was the receiver then sued for the correct payment of rent. They actually sued not for the whole term of the lease, but just the last two terms of the last 2 quarters of 1945 and for the future. Okay, so what happened then? Well, consistently with the old railways cases, Lord Denning held that if a promise is made, which to the knowledge of the promisor is to be acted on by the promisee, then the promisor is not allowed to act inconsistently with the promise. Equity will not allow that promisor to go ahead and resolve. The important part is that the promisor knows that the promisee is going to act to their own detriment by relying on whatever it is that was promised. That's the bit that makes it unconscionable to allow that promisor to go back on their word. So it's important to realise here at this point that promissory estoppel in equity was a shield and not a sword. Essentially, it just stopped someone acting inequitably. It certainly did not provide a separate source of rights, and therefore still, even though you're talking about, promises and enforcing promises, it didn't threaten the doctrine of consideration overly much, because all you were doing was really just the minimum equity. You were doing the minimum equity between the parties to achieve justice, and that is by stopping someone from going ahead and reneging on whatever it is that they promised. So here you have Denning making it very clear that he wasn't trying to undercut the doctrine of consideration. The principle of promissory estoppel never stands alone as giving a cause of action in itself. Okay, you can never do away with the necessity of consideration when that's an essential part of the cause of action. The doctrine of consideration is too firmly fixed to be overthrown by a side wind. Okay, so he's saying, don't worry about consideration. We're not tinkering around with that whole issue. We're just saying sometimes, even though consideration has not been paid, equity requires us to stop somebody from going back on their word. And so it caused a little bit of a stir, but not overly much. So promissory estoppel then was very clearly on the books in England. What was the situation in Australia? Well, it wasn't entirely clear until we had what I've called here a two-case assault on the doctrine of consideration by the High Court in the 80s. The first case was Legione and Haitley. That case didn't turn on the notion of estoppel. However, it was recognised as being applicable within Australia. And there was 2 judges in that decision that analysed it in terms of estoppel. We had a vendor and a purchaser of a property, and the purchasers sought an extension of time, and the poor old secretary for the solicitors of the vendor said, oh, look, I think that will be okay, but I'll have to get instructions. And that fateful sentence then took the firm of solicitors and the vendor all the way through to the High Court. In that decision, whilst it was recognised that the doctrine of promissory estoppel did apply in Australia, the plaintiffs wouldn't have succeeded because something as vague as saying, I think that'll be okay, but I'll have to check to make sure, wasn't clear enough to found an estoppel. I mean, if you're going to enforce what someone has promised you, then you really have to have crystal clarity on the terms of exactly what has been promised, and that wasn't sufficient in that case. But as I said, the case didn't turn on the doctrine, so it wasn't until we had the case of Walton Stores and Marr that the position was made absolutely certain for Australia. The High Court left us in no doubt whatsoever that not only was promissory estoppel here to stay, but my word, it was a force to be reckoned with. In this case, we had an owner of land that had negotiated with Walton Stores. Walton Stores in the 80s was, it was so hot right now. It was, the equivalent of, I guess, David Jones or Myers nowadays. And so they certainly had some commercial might, some commercial power. And they flexed those commercial muscles when they were dealing with dear old Mr. Marr and his building and construction company. What happened was that Walton Stores decided to open up a large shop in the middle of the Nowra business district. It started to negotiate with Mr. Marr, who owned a shop on site, and they agreed that the existing shop would be demolished and a brand spanking new department store, one of those newfangled department stores, would be built instead, all fully fitted out to Walton Stores specifications. The problem was that the time frame was very, very tight. Everything had to be finished by January 1984. It got to October 1983 and we still didn't have an agreement on foot between the parties, even though all of the major terms and conditions had been sorted out and everyone was comfortable with the deal. In fact, Mr. Marr was so comfortable that he had already started demolishing the old building. And eventually he said to his solicitors, can you please get a hold of Walton Stores and ask them, when are we going to get this agreement on foot, because I've got to start ordering supplies and I don't want to demolish this last brick part of the building without having an agreement on foot. In fact, he said he needed to see the final form of the written agreement within the next day or two. So he was getting pretty worried at this point. Walton Stores solicitors wrote to Mr. Marr's solicitors and said, we don't have any instructions, but we believe that formal approval will be forthcoming. We'll let you know if we need any amendments. Mr. Marr heard nothing further, waited for a couple of days, no amendments were requested. So Mr. Marr's like, right, we got a deal. And he signed off his copy of the lease that had been sent to him and returned it. His solicitor returned it to Walton Stores solicitors by way of exchange. So that basically meant that so far as Mr. Marr was concerned, a contract was on foot. He was just waiting for Walton Stores to get their acting together, sign their copy and send it back. Mr. Marr then proceeded to start the demolition of the older brick part of the building and got all of the demolition done so that he could comply with the strict timeframes. What he didn't know, bubbling away underneath all of this, was that Waltons was having some internal company organisational issues. They actually went through this restructuring process, and as a result of all of that, they were having second thoughts about the deal. Consequently, they told their solicitors to go slow on the Marr deal in Nowra. They all knew that Mr. Marr was actually demolishing the old building and starting, construction work on the new part of the building. They waited for 2 months and then they told Mr. Ma that they weren't going to go ahead with the deal. At that point, not only had all the demolition been finished, but 40% of the new building was complete. Rather extraordinary set of circumstances there. Now, there were clear problems in making an argument of equitable or promissory estoppel here, weren't there? Because it would have been a very clear case of estoppel being used as a sword and not a shield. It wasn't, as it had been argued previously, being used to stop someone from enforcing their strict contractual rights. There wasn't even a legally binding contract here on foot between the parties, so this really was uncharted territory. It certainly provided a source of rights for Mr. Ma. Essentially, what the court did was kind of like enforcing a gratuitous promise, that is, a promise that was not supported by good and sufficient consideration so far as the law is concerned. Why would it do so? Obviously, because of equitable reasons, to stop inequity. So it was held that equity provides relief from unconscionable conduct of the defendant in ignoring the other party's assumption. The court tidied up in a conceptual way all of the various different kinds of equitable estoppel that have been given labels over the years. So estoppel by acquiescence, estoppel by encouragement, proprietary estoppel, promissory estoppel. What the court said was they're all part of this one notion of equitable estoppel. Once the court had found that organising theory and said that it all comes down to the court wanting to stop inequity or unconscionable conduct, then really there was no theoretical reason to stop equity from being used in this situation via estoppel as a sword and not a shield. Justice Brennan's decision is the decision that kind of gets quoted most often from Walters and Ma, and his exposition of the 6 elements really is quite a commanding one. I probably prefer them to the ones that are set out in law, just because it's always good to get it from the horse's mouth, so to speak. So these were the elements that were set out in Justice Brennan's decision. I won't elaborate on the 6 elements any further here. What I'll do is end this video now, and I will come back in the very last video for this series, I promise, no pun intended, and I will step you through each of the 6 elements. Bye for now, guys.